Shall we start, sir?
Yes, it is 11:30. Please start.
Okay. Good morning, one and all. Respected speaker, Ms. Jaspreet Kaur, and in charge principal, Dr. V.A. Rankhambe, vice principal, Dr. B.N. Pawar, ADSU sir, IQAC coordinator, Dr. R.S. Jirenge, NRF coordinator, Dr. Mrs. S.S. Shukla, Dean Faculty of Science, Dr. S.G. Pawar, and all my colleagues and students. I welcome you all on behalf of Institution Innovation Council of Yeshwantrao Mohite College and Bharati Vidyapeeth deemed to be university, Ministry of Education, Innovation Cell, Ministry of Commerce and Industry Cell, all of us are celebrating Intellectual Property Awareness Week under National Intellectual Property Awareness Mission from 26 April to 29th April, and we have celebrated World IP Day on 26 April. We are privileged and thankful to Ministry of Education and Kalam program for IP literacy and awareness, that is Kapila program, for selecting our college as online center for conducting session on IP awareness. This program aims to establish pre-requirement of IP filing ecosystem in an educational institute, and thus creating a culture of systematically protecting new ideas, research, innovation, having national and global relevance. Now I request in charge principal, Dr. V.A. Rankhambe sir, who motivate us for research and innovation. So I request sir to welcome, to give welcome speech.
Thank you, Dr. Sharada Gadale, the IISc coordinator of the college. The prime speaker of the World IPR Week special lecture series, Ms. Jaspreet Kaur. Vice Principal of the college, Dr. B.N. Pawar sir. IQAC coordinator, Dr. R.S. Jirenge sir, and members of IQAC cell. Assistant coordinator for NAC, Mr. Prashant Patil. NIRF coordinator, Dr. Supriya Shukla. IIC coordinator, Dr. Sharda Gadade. Members of the committee, my colleagues and dear students. In my capacity as the in-charge principal of the college, it remains my pride and duty to acquaint the speaker and the students with the milestones in the history of this particular university in a nutshell. Madam, Dr. Patangrao Kadam Sahib laid the foundation of this historic institution in the year 1964, and in the year 1996, the then MHRD Government of India, on the recommendation of UGC, accorded the status of deemed to be university. The motto of university, that is social transformation through dynamic education, is the driving force of all our actions. Dear students, to save the time, I also request you to visit our college website ymc.bharatividyapeeth.edu, which confirms our claim and credits in various respects and various fields. As our university has got the highest A+ accreditation by NAC in the year 2017, Category 1 University gradation by UGC, having declared to have ranking among first 100 universities by NIRF, among top 10 universities preferred by overseas students. In all, there are 29 units which have been spread over 8 campuses across India. We offer education of 12 faculties and 324 programs. Students from almost all the states of India and from 48 countries consider our university and the college as their most preferred destination. So once again, I welcome Jaspreet Kaur and you all to the program which has been organized by the College Institution Innovation Council and Kalam Program for IP Literacy and Awareness, popularly called as Kapila, as well as the National Intellectual Property Awareness Mission, NIPAM, to observe the IP Literacy Week in the country. And just before time at the outset of this particular day, Madam Jaspreet Kaur was having a discussion and she congratulated me for having this particular opportunity for a privileged colleges. And madam, we are really thankful to you, thankful to all the authorities of Government of India for giving this opportunity to our college. The short form of Kapila reminds us of the ancient sage who was in fact the 6th century Vedic sage and is considered as the founder of Sankhya Darshan, the oldest of the 6 schools of Indian philosophy. Vaijnanikasya Kapila, Kanada Sushrutastata, Charko Bhaskaracharu, Varaha Mihra Sudhi. Coincidentally, as per the historical sources, the first patent of the world was also claimed in Greece in the same century. Dear students, we all are meeting at the moment when the new education policy 2020 is knocking our doors for its implementation, and which expects us to go for the era marked for interdisciplinary knowledge. Hence, welcome to this important session on intellectual property rights, which is in fact a part of law education, but a must-to-do things for all intellectuals belonging to all faculties. We all know that the copyright, trademark, patent, trade secrets are the most common and frequently used terms in the intellectual community. And this particular session is to acquaint you with these concepts and roadmap which one needs to undertake in future. Today's lecture is but a new awakening, and hence I must appreciate government's efforts by launching this initiative, which certainly speak of their commitment and determination to make this academic community aware of the IPR. To understand the importance of today's lecture, I appeal you all to read the history of Dr. Raghunath Mashelkar's fight and historic struggle for turmeric patent, which is now in the name of India. Dear students, it is certainly my privilege to inform you that yesterday on 26th day of April 2022, Bharati Vidyapeeth deemed to be university has also started its incubation center, which was inaugurated at the hands of the health minister, the state health minister, Mr. Rajesh Tope. These things which are happening around us and have to be valued in totality. Hence, it is very much essential to acquaint yourself with the ideas of patent, copyrights, trademarks, etc. I hope you will enjoy this lecture, which is going to make a lot of difference to your career in the recent years. Once again, I welcome the Prime Speaker of the program, Jasprit Kaur, and appreciate the efforts taken by Dr. Sharda Gadale, who is the organizing secretary of this particular program. Thank you. Thank you very much.
Thank you, sir, for your encouraging words. Now moving towards the session, today's speaker, Ms. Jasprit Kaur, madam, for the lecture on IP awareness. Madam is an examiner of patents and designs and having experience of more than 2 years. IPR newsletter, which is promotion of industry and internal trade. So with this, I welcome ma'am and I request you to start the session. Thank you, ma'am.
Thank you so much, ma'am, and thank you, sir. Your speech was great, and I myself came across some new things, and I'll definitely Google and read about them. And I welcome you all to this presentation that is by the Patent Office Mumbai, and we are the part of this NEPAM, which is under the as all of you know that. India is commemorating the 75th anniversary Independence Day, and it is under the Azadi Ka Amrit Mahotsav. So, Government of India has taken an initiative to educate the 1 million students across the India about the IPRs. So here I am to tell you something about the IPRs, and we have curated the presentation in a way that everybody from the each and every background, like arts, as I have I came to know that the students are from the arts, science and commerce background. So we have curated the presentation in that way, in the simpler terms, so that each and everyone can understand in the very simpler manner. So here I would like to start with the presentation. So I hope I'm audible enough and there is no technical or internet glitch, and also my presentation is visible to all of you.
Yes, ma'am.
Yes, madam.
Okay,
Yes,
so we can
absolutely.
start with the presentation.
Yes.
So as this is the first slide, this is NEPAM, that is stands for National Intellectual Property Awareness Mission. And also I'll take this presentation in the dual mode so that language should not be a barrier. So I'll speak in both English and Hindi. And okay. So when I talk about the intellectual property, when I say the word intellect, what comes to your mind? So this is my question to all of the audience who is present here. So when I say the word intellect, what comes to your mind? Anybody from the audience? Any journal thing that comes to your mind, any kind of definition, any kind of okay. So when I say the word intellect, so it comes to my mind that it is something about my intelligence, or it is something about my mind. So the intellect means the creation of mind. Anything, the idea that is being created by our mind. So in the intellectual property, when I say the word property, the thing comes to my mind is the money, a piece of land, maybe some gold, or maybe something that is, very, very expensive in nature. So in the word intellectual property, the definition, the term, so property, so if anything is created by my mind, or anything, any idea that is in my brain, so that is property of my only. That is, that is something that I own it. So intellectual property talks about the IPRs, talks about the ideas that come to our brain while we are thinking. So there is a specific organization which is, there for you to save that idea, so that, nobody could like infringe it, duplicate it, or copy it for their own profit. So in the IPRs, we are going to talk about the patents, designs, trademarks, GIs, copyrights, SICLDs. So like here. So here you can see three figures. Okay. So when I talk about the patents, so patent, we deal in the term of the patent when some innovation or invention is there. Suppose for example, the invention of some fan, some invention of some computer. So I basically belong to the computer science trade. So I'm by education, I'm a computer science engineer. By profession, I'm a techno-legal person, because I'm working in an office that deals in the techno-legal term. So what does it mean by when I say the word techno-legal? So in this office, we are doing the both work. So we are following the 19 Patents Act 1970 for referring to the various acts, sections and laws. And if I talk about the technical thing, that I am a computer science engineer and I deal with the inventions that are particularly related to the computer science. So the intellectual property in the domain, under the domain of the intellectual property, we have the 6 type of IPRs. First one is the patents, second one is designs, third one is the trademarks, fourth one is the geographical indication, and then copyrights, and then SICLDs, that stands for the semiconductor integrated circuits layout designs. So when I talk about the patents, it completely deals with the technical section. Like if I talk about some computer science thing, like in the second slide. So here comes the three figures. The first one is the image of some laptop. Okay. And there are two arrows pointing toward this laptop. One is the very little tiny arrow and one is the big fat arrow. So if I talk about this laptop, so here you can see the three things. One is the keyboard, and this fat arrow is pointing towards the display of the laptop, and this thin arrow is pointing towards the Apple logo. Okay, so if I talk about the IP, so if I talk about this LED display, so LED display contains all the technical features. Like if you think about some gaming laptop, okay, so gaming laptop has the extra screen features that are the some good great graphics. Okay, so there are some graphic cards where you can put you can add on, or you can just put it into the computer specifications to add to the property of the great graphic graphic experience. So if I talk about the invention or innovation, it comes under the domain of the patents. And if you see this thin arrow which is pointing towards this Apple logo, then this Apple sign is the trademark. It talk about the second number IPR, that is trademark. And if you talk about this body of the laptop, as you can see that there in these times you can see the every day the things are getting thin and thin. And you can see the body of the Apple laptop is very much different from other, like it's very sleek in nature, it's very thin, and you can see the angle to which it can tilt into. So if anything that comes under the term of the design, like body of the laptop, it falls in the category of the IPR, that belongs to the design. And whenever I talk about the design, what comes to your mind? Maybe the design of this watch, the dial is this rectangle shape, or the design of my spectacles. You can see the a different frame, like it is the round one or it is the oval shape. So if you have something in your mind that is, very unique in the design, maybe you can talk about the shape of this, uh, what you can say, the AirPods, or you can talk about this mouse also. So anything, if any distinguished design in your mind, you can register it in under the design domain of the IPRs. And in the second figure, the arrow is pointing towards the LED display. Here you can see that arrow is completely, pointing towards the display. It is showing that it has some great technical features, like this, the resolution of the display, like the brightness part, like the if you are a gaming fan, then you obviously buy a gaming laptop. Okay, so in case of the gaming laptop, the screen resolution is very high, and the graphics are, that faster, so that they can match with the motion of the gaming. So if somebody is coming to my office, coming to us, like coming in my office, and he's saying like that, ma'am, I have made this invention and I have made this laptop, and this screen has the particular feature that are better in nature, that are already existing ones, or there is something unique in these features that I have invented by my own or invented by myself only, that also goes for the grant of the IPR, and that too with the patent right. So I hope you are clear with this term, patent and design. So in the case, if you have something in your mind that completely relates to the something, some great invention or innovation, that deals with the patent. And in the patent domain, not only computer science deals, like in the chemistry, there are the dealing with the drugs also, the medicine field is there, biomedical is there, and any kind of new equipments like that belong to the civil, mechanical, electrical, electronic, anything that relates to the something new, that is something new or already or better than already existing one, it comes under the domain of the patent. So whenever you see something that is related to innovation and invention, it comes under the patent. And next is the design. As you can see, the body of design, it falls for the design. Sorry, the body of the laptop, it falls for the design IPR. And third one is the Apple sign. It falls for the trademark. Okay, so whenever we buy something, it comes with the user manual. Like the presentation I am presenting here is completely made by me, and the way I am presenting it is completely my own. So anything that is created by you only, you just own the you just own the right over it. That is a copyright. So for the copyright, you do not need to register it with the copyright office, because automatically this is your moral right. Whenever you create something, it morally just you just morally own it. But to keep it safe, and if in the future if somebody is going to copy that thing, and if you want to sue them in the court and all, then if you have a registered copyright and if you have registered it with the office, then you have evidence to show in the front of the court that, like, I have this copyright and I am owning this. And the fifth one is the layout of the ICs. Okay, so keep it in mind whenever. There is also a design term after the SICL. This is a semiconductor integrated circuit layout. So in this case, we are talking about the technical design. We are not talking about the appearance, as I have talked in these previous figures. Like in this, we are just talking about the outer appearance in the second figure. Okay, so it falls under the category of design. If you talk about the SICL design, then we are talking about the technical specification. Like this IC board has so many ICs, chips, transistors, diodes, and so many technical features. So SICL design talks about the technical feature only. So we have a Delhi office for the grant of the layout of the ICs. So my organization also gives the SICL design, IPR, in the field office. So I hope I'm a bit clear. And in the upcoming slides, we have great videos and audios to make it more clear. So, okay. So as I have told you earlier in the first slide, that what are the IPRs? So in case of the IPRs, we obviously need a brain to create some idea. First, our brain creates some idea. Then we need some resources to exercise it, and we need some labor to implement the everything that comes to our mind. So this comprises whole, and it makes the IPR property. So it makes the IP property. So in the intellectual property rights, okay, whenever we buy something like a piece of, whenever we buy some land or a piece of land, we go to some tehsildar's office, the district office, to get it registered into our name. Okay, so if you have some idea in your brain and you just want it like badly, you just want it to be your own only, and you just don't want it to be copied or exercised elsewhere in the name of some other person. So where would you go? So you go to the patent office. And these days we are electronic office, we are completely digital office and following the footprints of the digital India. So you just go to our website and check and go and register your invention with us, and you can just simply complete all the formalities, and you can just file, you just claim for the invention. So what is the importance and significance? So why talking so much about the IPRs? So what is the idea behind this awareness program? So what is happening is, like, people have so much idea in their mind and they are creating or manufacturing something, but this same person do not same person is not aware about the protecting their rights. So what happens is, it is I'm talking about the common world, of course. I'm not talking about some big business tycoons, and because they are already, they have complete their they have completed the different IP teams with them, and obviously there are some great organizations which do they have their IPR cells, but in some cases the people are not aware. So in what happens in that case is, people make some invention, they do some manufacturing part of it, and they just flow their products into the market, and they do not register it with some kind of organization, and they do not, like, the paper do not recognizes that you have made this particular thing, and that is a completely new in the nature. So what happens in this case is, like, anybody else can copy your idea, and they can take over the real the real thing from you. So to protect the inventor, to protect the person who has made this complete innovation, there is the importance and significance of the IPR. So it excludes others from infringing your rights, from infringing their your discovery or invention, sorry, the invention. And it also utilizes or commercialize, you can just utilize that invention for your earning, and it can give you some kind of monetary benefit. How? I'll explain it to you. So how can you do the utilization and commercialization? So first thing is own use. Okay, so here are the so many students already that they are already who are present here in this presentation. So there might be some case like you one of you want to go to the higher universities or some, or to the abroad for your higher studies, like some MITs or Stanford or the other prestigious universities in the world. So sometimes students come, they register their inventions and they register their applications with us, and they get the patents. And they add their number of patents published, and they add the number of patents they have owned. They own in the field of whatever so-called field they are going into or they are started into, and this adds the brownie points to their CVs. And in some cases it also happens, like in the I myself have seen such kind of applications where the people from the engineering background, they have made inventions and they have given the rights, they have transferred their rights to some company, some startups, or maybe the companies like the TCS or the because the TCS and Infosys, these are the companies who mostly have the youth, the freshers in their company. So they make the invention and they assign their rights, or they license their rights to some company or the organization. From them they can earn some money. Or third is the merchandise. Why we have put the Disney word here? We have seen like that the Disney is the king of all the cartoons and all the animated series and all the animation. So have you ever seen the kids wearing those t-shirts where Disney sign is there, or the trademark of Disney is there, or some like the cartoons like from Mickey Mouse, the very popular very popular cartoon that is being pictured over there on the t-shirt. So in this case we are talking about the merchandise where they can get some money. The vendor can also get some money from the name maker. And fourth is the franchisee. Whenever I say the word franchisee, only thing that comes to our mind is food. Like if I talk about the franchisee, you think about the Pizza Hut or McD. So from there also the person can earn the money. So what is the difference between the common person and businessman? If we talk about the common person, I'm talking mostly about the students or the researchers that are making the invention. So some people, they just use it for their pride. Like I have registered so and so number of patents with the patent office, and the other one they can use it in their academics. Like I have told you earlier that if you want to apply for the higher education, you can just get a patent from the organization, from the government of India. And for that cause we have office like in the 4 locations. You can just register your invention and you can get a patent, trademark, design, or any right you have, any right you want to have, and just add it to your CV for your academics part. And for a businessman, they can commercialize it, and having a great product that is being manufactured by you, that is very unique in the nature, or that is better in the nature that is already existing the prior one, it adds the brand value to you, and person can earn or invest some money into the good brands. So what is a patent? It is a grant by the sovereign, that is government of India or state, to a person, which is giving the exclusive right to stop others from making, using, exercising, vending, and importing your discovery, importing your invention. So it goes for the limited period only. Why we are saying it for the limited period? Because we want to encourage more and more inventions in the, if we are not going to limit the period, so it may just stop and it may just demotivate others to not to create something that is new in the nature. And in exchange for disclosing it in a patent specification such that anyone having every skill in the art can reproduce the invention. So we have this phenomena of the person who has skilled in the art. So suppose I'm a computer science engineer, I'm a common person. So I have come across something that is, I have come across some invention that is being registered with the patent office, and the office has not given any any right to it. They have just published it on their website, like they have found this application and they are registering it uh, for the patent registration. So the person like me who knows the software engineering, who, the person should be able to understand the invention you are making. Okay, so it should not be the frivolous one, like it should not be like this only कि हाँ ये बन गया है invention तो इसका ये end result होगा. It should be nothing like that. There should be a proper drawing and there should be a proper proof that it may be industry, it will be industrially applicable also, and it will be whenever you get a patent right over it, it would be useful in the society also. So the another thing is, the patent gives the right to exclude others from using your invention, as I have told you in the earlier slides, and owner has the qualified right to use the invention only. That is why we are focusing on the IPRs. So here comes the another interesting slide. This is the famous inventor. This slide talks about the famous inventor and their inventions. So this is the picture of Mr. D. Panning, the George Alfred D. Panning. He was a civil engineer and he has made this efficient pankha pulling machine. And he has, petitioned in front of Government of India for grant of the exclusive privileges for this invention, so that nobody else would claim in the later future that we have created this thing. Okay, so these are the scientists. So Mr. Edison and Sir Edison, and he has made the invention of this phonograph. Sir Graham Bell for the telephone, Wright brothers for aeroplane, Louis Pasteur for rabies vaccination, Alexander Fleming for the penicillin. These are the famous Indian inventions. The first one is the Nano Car. It is for Tatas and it providing an opportunity for middle income families. And you can see that there is a very different design and it's a very compact car and it is very comfortable for the people who are low in budget. And second is the hepatitis vaccination. So it gives the healthcare access to the large number of people who have just low purchasing power. And this one, third one, is the very affordable food, Jaipur food, that is very affordable, and it is for the people who are differently able. Okay, here you see the 4 different images and you can sense that like nature of the invention is very simple. If you talk about the first figure, the image, you can see it. There is a very cute little baby. He is taking the bath, as he is wearing this shower cap. So this invention seems very simple in the nature, yet very useful. Like if you see that it is protecting the baby's eyes from the harsh chemicals of the shampoo. Okay, so we have also granted the patent in the field of such kind of useful invention that are very novel in the nature and yet very useful, very simple yet novel, yet very useful in the nature. And second thing you can see is the wristband. So right, these days we all are wearing this smart band, smart watches to sense our motions and sensor motion and exercise and everything. So how here you can see the a screen that is very being projected into the wrist from your mobile phone, and this band is being connected to the mobile phone. And third one is this thing, the chip that is working as a card reader, it is yet to be flown into the market. And right now you are already using the card readers at the various shopping malls, and the various even the smallest of small shops are using these kind of online, these kind of card readers. Okay, so you just not don't need to carry the the bunch of cash if you go to the if you're going to visit a market. And fourth one is the drone camera. So it if you want to have, you just don't need to fly high in the sky for those aerial view shots. So do you just have a drone camera, you just set an angle, just project in the direction, in whatever direction you want it, and you get the best of your pictures. Okay, so here comes the another IPR that talks about the design. So what is the difference of the patents and design? So patents mostly talks about the technical part, the functioning part. But if I talk about the design, design simply talks about the appearance, the outer appearance of something, and it does not go into the details that how that article is properly working. So in the case of the design, in the case of the design, So in the case of the design, we talk about the feature of shape, configuration, pattern, ornament, or the composition of the lines or colors, which could be applied to the any article. Here you can see the four figures. First one is the sari. Second is the fan. You can see the fan is in the dual color, white and brown. And third one is the Sabyasachi bag. So here you can see the trademark of the Sabyasachi. And fourth one is the portable washing machine. Okay, so if when I talk about the design, I only mean the ornamental or aesthetic aspect of an article, that is the outer appearance only. Okay, so it could be applied to the any article by the industrial process or means, or whether it could be manual, mechanical, or chemical, and it can be separated or combined, and it is the finished article that appeal to the outer eye only. So the term of the design is 10 years, and it could be extendable to the 15 years. Here you can see the another figure, like so there are 8 type of different bottles, and you can notice that the configuration, surface pattern, and shape of each and every bottle is different from each other. Every bottle differs in its size, shape, and configuration. Nobody is talking about any kind of technical phenomena like the pouring capacity, the liters it can hold, or the way you can just cap it. Okay, we are just talking about the outer finishing of the article. So here are another 5 images. This is some beautiful wallpaper. This is alarm clock, table lamp, and this is a toy, and this is the inhaler. So if you have something in your mind, if you know that it is a very unique and distinguished design, and it is not yet revealed in the market, and it is not yet present in the market, you can just apply for the IPR for the design in the design office. Or also you can also register it under the set of article term also. So set means a number of article of same general character, like a set of this jewelry set, this teapot set, and this is sofa set, and these are the mojuries. So how filing of how you can file the design application. So if you are filing it physically, like on the paper you are filing it, so you just file in this any of these 4 offices. Then we simply digitize it, and there is electronic processing module that works in the patent office Kolkata. So Kolkata is a big design office, and you can simply like e-file also. So it comes under, if you file for the physical application, then we just simply digitize it, and it got processed it gets processed into this electronic processing module, and further we start for the examination, registration, publication, and post registration process. Okay, so whenever you file an application that goes for the examination, we register it and we publish it on our website. Why we are publishing the inventions? So it gives, you know, the publication of your invention. It is to give the idea to the public that somebody is already working on this kind of invention, and what are the various things that and what are the various things that you can just add into that invention, or what are the and you know to keep the invention in the public eye. It is also very safe for the patent office. Like sometimes we receive such kind of applications that are already existing in the prior art, and in that case we also take the pre-grant oppositions or the post-grant oppositions. So sometimes we come across the this idea of the pre-grant also. Like if somebody is trying to copy your invention, then he or she can just argue about it in the front of the patent office. Like this invention is already in the market, we have already made it, and this person is trying to copy it. That is why the publication idea comes in this patent office. Requirement to file an ordinary application is, so application fee is rupees 1,000. It is for individual like the normal person, any student or any person. Small entities or startups, if you fall under the category of the any small entity or the startup, and rupees 4,000 for the any other. For the others means the companies, the organization. So application form 1, you need to fill these details, and you need to file a representation sheet. So this is the specimen of representation sheet. So if you want to file for a design of something, like this is the tea kettle design, okay, and the applicant has filed this drawing. So this is the specimen of the representation sheet. So just the novelty resides in the shape and configuration of the teapot, and no claim is being made by the virtue of this registration in respect of any mechanical or other action of the mechanism. Okay, how we can strain the tea into the strainer, or how we can pour the tea out of this nozzle. Okay, so the no claim is made by virtue of this registration. It is only talking about the prospective view, and the novelty only resides in the shape, appearance, and the configuration. And this is the certificate which is to be given by the Government of India, the Patent Office, for the certificate of the registration of the design. Here you get the design number for your design, and the date, and the sign of the competent authority, the Controller General of Patent Design and Trademarks. So here comes the publication part. So all registered designs are published in the Patent Office Journal, and particulars of the registered designs are published along with 1 or 2 the best view of the representation. So we usually publish in our design sheet the perspective view of the invention. So third one is the trademarks. So okay, so as I'm sure that all of you know about the something about the trademarks. So whenever I say the word trademark, the only thing comes to my mind is that is logo of something. So concept of the trademark is that trademark can be any symbol, word, or device, or anything that, or any combination, and it identifies and distinguishes the source of the goods or services of one trader from the other. Like if you go to the market, there are some articles, like if we talk about the washing soda, uh, the washing powder for the clothes, like it comes from the different brand. The Tide is one brand, the Rin is one brand, and the Wheel is another brand. Nirma is a soap. Okay, so it identifies and distinguishes the source of the goods or the services from the one trader from those of the others. So what is the function of the trademark? So trademark gives the exclusive monopoly. Like if I talk about the Apple products, in the engineering part, if I talk about the if I talk about the electronic products only, I talk about the HP, the Dell, or Apple company. So every brand has its own value. Every brand has its own value in terms of the quality of the product, and it allows the business entity to build a public goodwill. Okay, and the reputation comes with the brand name. And the next time when you visit the market, you just don't need to read the name of the anything. You just see the logo, and just the thing comes into your mind that we are talking about this company. So trademark could be anything. It could be a service mark, trade name, collective mark, certification mark, tagline or slogan, shapes and sound mark. Although the research is going in the direction of this, that sound mark, how can we just simply identify the one sound mark from the another? But still there are some great sound marks that are completely eligible for the trademark purpose, like IPL is going on these days, right? So whenever they start IPL, they start with the great sound mark of the IPL. So that is also a trademark. Nobody else could use it. Okay. And have you ever seen that ad by Britannia? It also has a sound mark. That jingle it plays like ting ting ting. That is also the sound mark of the Britannia. And here are some figures. This is the logo of the McDonald's. Okay, so here they have written nowhere the word McDonald's. Okay, I just saw this the reversal of this W, which makes it into the M, and that too in the red background. And I just immediately recall it like the McDonald's. So this is the beauty of the trademarks. And another thing is the bottle of Coca-Cola, Google, Nike, and Adidas, Statue of Liberty, and Naukri.com. This is the trade name. And Dil Mange More, this is the tagline. And this is the logo, Bureau of Indian. This is the certification mark, that is BIS, Bureau of Indian Standards. So what is a good trademark? So it should be distinctive, and it could be inherited also, or it could be acquired also. It should not be deceptively similar. It should be honestly adopted or coined, but it should not be deceptively similar. Now, you can also come across, you have seen like, there is lots of selling of the first copy in the market. If there is a Reebok, then there is a Reebok also. And you have also seen uh, the duplicacy of Puma products in the market. So it is completely up to the trademark holder or the genuine company to sue those kind of people who are just selling in the name of the copy of the big brands. So a sign of a good trademark is it should not be similar to anything else that is already existing in the market. And if you are adopting for a new mark, just it is a completely advisable to complete do some homework, and just do a research and just evaluate it, that it is not being similar with the another one already existing one. So how to indicate your trademark? You have in the case of the registered or unregistered, or if you have application pending with the trademark office, you can still, if you have applied for the at least applied for the trademark, you just simply put the TM in the subscript of your organization name. But when it got registered, then you can just put a R in a gola, then it shows that this is a registered trademark. So how can you protect your trademark? So its registration is optional, but if you are registering it with the office, it has the definitely it has certain advantages, and it adds to the brand value. And you can initially register it for the 10 years, and it's renewable in the nature. You can extend the time for the 10 years. And if you are not using your trademark and if you are not renewing it, then trademark rights would be lost. And existing trademark registration, so we use the Trademarks Act 1999 and Rules 2017 to govern the registration, registration of the application for the purpose of the application filing and registration of the trademarks. So you can just simply visit the ipindia.gov.in for the further information. So this was all about the patents, design, and trademarks. So here comes the interesting part of this presentation, that is copyrights. So whenever we coin the term copyrights, the only thing comes to in my mind is movies, music. So copyrights we give in the field of the literature. So these are the bundle of rights and it comes automatically. The day you have created something, the rights come automatically to you. This is the moral right. Okay. So this is the exclusive right which is given to the creators of original work of authorship. So it allows the owner, so they can choose uh, to present or make their work available to the common public, and it prevents the unauthorized copy or reproduction. Okay. And copyright cannot protect an idea, as you already know. If you have some idea, then you just need to register it with the under the domain of the other other IPRs. If you want to file a copyright, anything that is in the public domain, anything you want to protect it that just belongs to the artistic part of yourself, it comes under the domain of the copyright. So what is the criteria for the work to be copyrighted? It should be original. Okay, it should not be copied from anybody else, and there should be a creativity. And there is some, there is something, if you're writing, suppose you are writing some song, and it is, if it is adapted from something else, you need to talk to that person for the transfer of those rights. These days YouTube is full of these mashups. Okay, the mashup, the production of this mashup is okay, but the original rights are only with the person who has originally created it. Okay, so if you want to make a mashup of the various songs that were already like 60 years, 50 years, or 10, maybe 10 years or 5 years old, you just need to adopt, or you just need to inherit those rights from that copyright owner. Then only you can make that work public, and then only you can just process it or make it. So uh, what are the different fields in which we grant the copyrights? The literary work, if there is a dramatic work, and here you can see the sections. This is literary works come under the section 2O, and artistic work comes under the definition of the artistic work is given in the section 2C. Musical work in case of cinematographic films, in case of sound recording works, in case of the dramatic works. You can target in dramatic works, they are probably talking about there's some, the any kind of drama or play that's being played on the stage. So what are the rights of the authors of the copyrighted work? The copyright could be, the rights would be, defined into the two different manners. The first one is the economic right, and second one is the moral right. So economic right is a transferable right. You can assign to those right to somebody else. अभी आप एग्जाम्पल लेंगे सोनी लिव जो चैनल है, सोनी लिव क्या है, ऐप है, और उसके ऊपर कोई शोज आ रहे हैं डिफरेंट डिफरेंट, द वेरी पॉपुलर कपिल शर्मा शोज थे। तो वो जो चैनल है उनके ब्रॉडकास्टर्स हैं, जो ब्रॉडकास्टर्स हैं उन्होंने अपने जो शो के राइट्स हैं, दे हैव गिवन इट टू द सोनी लिव टू air that program or show in their on their app. So these are the economic rights that would be transferable. Next is the moral right. Okay, so if somebody is creating some script, if I talk about the movie script or the show script, The moral rights are only with the person who have originally created it. These are non-transferable rights. So what is the scope of economic rights? So if you have an economic right that is transferable, so in that case, you can reproduce the art. Second, you can distribute it. So you, as you already know that there are the various distributors involved in case of the art and literature work, who can disseminate the physical copy of the work, and you can just rental right to that content. So as you all know, as people watch lots of this series movies in these OTT platforms. So some OTT platforms, they just rent the movie for a particular period, and they just dispose of that thing. So distribution right is also one of the right that is available in the copyright domain. And next is the right to create the derivative work. You can just simply adapt some idea, translate it, compilation there, like if your Chennai movie, some Tamilian movie, you are translating it to the Hindi, or you can compiling some videos or some sound recordings, mashups, any kind of cinematic work. And scope of the economic right also talks about the right of communication to public. Okay, if it is talking about some kind of stage performance, if you are presenting your work by the interactive communication means, like with the video conferencing, or any kind of the online platform, or in the offline mode on the stage. And right of public performance, you can just, if you are the original creator of the content, you only have the right to perform that work in the public. So scope is right against distortion, okay, and the right of recognition. So it is just talking about the everything that I have told you in the previous slides. And this is the term of the protection. If any film and sound recording has a copyright, then it is from the 60 years from the date of the publication. The date it has been published, the date it has been released, it holds the copyright from that day, and it is from the life of the author. And plus 60 years, these 60 years would be counted from the death of the author. Okay, so this is the most time that is given. This is the the larger time that is given in these copyrights. And broadcast, in case of the broadcast reproduction right, it is 25 years from the year which is following the year of the broadcast. If you have started broadcasting from this year, from 2022, and then it will be available for the next 25 years. It will be active for the next 25 years. And in case of the performance right, like if some artist is performing on the stage from the on this date, on the today's date, then it is 50 years from the year following the year in which performance is made. So what is the application procedure? You need to fill the form 14, and every application can be filled in the copyright office. It should be by person, by post. You can just post your application, and you can just, or you just e-file your application, and payment should be made from the payment gateway. So this is the prescribed fee. So very nominal fee we charge for the copyright, like literary, dramatic, artistic, or musical work. This is 500 rupees, and it is very cheap for than the expensive cup of coffee. And in case of the artistic work, it is to be used or capable of being used on the goods and services. So it is 2000. For sound recording, it is 2000. For cinematographic film, it is 5000. So this is the examination procedure. When we receive the application in the copyright office, first formality check is being done, and then we find if then we scrutinize the application. If we find any kind of discrepancy, then we issue the discrepancy letter that is issued to the applicant. And if there is no discrepancy, then there is approval by the deputy registrar. If discrepancy letter is issued to the applicant, in that case the application will be abandoned. And if we remove the discrepancy, then there will be a approval by the deputy registrar. And if there is no approval by the deputy registrar, in that case, applicant then we schedule for the hearing. So we do give the chance of applicant to be heard before the registrar. And if the applicant is able to convince the registrar, then the registration would be approved. Otherwise, you just reject the application. And the next part talks about the SICLDs. This is the semiconductor integrated circuit layout design. And we have SICLD office in Delhi. In the SICLDs, you have this board which has some input output pads, registers, transistors, diodes, metal tracks, or the pins, micro pins. Okay, so you just, if you have something in your mind that is very unique in the design, and it also adds to the some great technical advancement to the already existing ones, in that case we you can just apply for the SICLDs. And this is the various forms. You just need to apply through these forms. And why SICLD is so popular? So SICLD is the great organizations like ISRO, NASA, the various the satellite, in the satellite engineering, in the space technology, and in case of the advanced IT technology in the medical field also, we are using the SICLDs. So, ma'am, before moving to the slide from the geographical indication, I would like to know that we have made a video for this IPR. And kindly tell me if you are able to hear the video, and also if you are able to see it properly.
Okay, ma'am. Okay.
Okay, so you all are able to see this screen by Google Chrome.
Yes, ma'am. Yes, ma'am.
Okay, so now I'm going to hit the play button. Kindly tell me if you're able to hear the proper sound.
Oh. Audible, ma'am.
Audible, no?
Yes.
चिंदी चोर के साथ घमासान के बाद अब आईपी नानी बिजी हो गई अपनी पोती की शादी की तैयारियों में। संगीत वाले दिन जब छोटू उनसे मिला तो
वाओ नानी, आप तो बिल्कुल छाए हुए हो। आपके सामने तो मधुबाला को भी कॉम्प्लेक्स हो जाए।
ओए, मस्का लगाना बंद कर। ये बता तुझे क्या चाहिए?
नानी, आपने तो मेरा दिल ही तोड़ दिया। क्या एक प्यारा सा लाडला सा बच्चा अपने नानी को कॉम्प्लीमेंट भी नहीं दे सकता?
अच्छा चल, एक्सेप्ट किया तेरा कॉम्प्लीमेंट। अब बता तुझे क्या चाहिए?
मुझे कुछ नहीं चाहिए, बस आपकी हाथ की वो स्पेशल वाली चाय पीनी है।
बस इतनी सी बात के लिए इतना बड़ा मस्का?
मस्का नहीं नानी, आप आज सचमुच बहुत ही रॉकिंग लग रही हो। ये साड़ी आप पर बहुत ही अच्छी लग रही है।
अरे ये तो स्पेशल लखनवी चिकनकारी है। लखनवी चिकनकारी पूरी दुनिया में मशहूर है। ये अपनी खूबसूरत और बारीक एम्ब्रॉयडरी के काम के लिए फेमस है। लेकिन पता है इसकी सबसे बड़ी खासियत क्या है?
क्या है?
ये एक रजिस्टर्ड जीआई है।
जीआई? वो क्या होता है नानी?
जीआई का मतलब होता है जियोग्राफिकल इंडिकेशंस, हिंदी में जिसे भौगोलिक उपदर्शन कहते हैं। ये किसी समुदाय का बौद्धिक अधिकार है। वो विरासत जिन्हें प्रोटेक्ट और एनकरेज करने की बहुत आवश्यकता है। मुख्यतः इन टाइप्स में रजिस्टर्ड होती है नेचुरल गुड्स, मैन्युफैक्चर्ड गुड्स, टेक्सटाइल्स, हैंडीक्राफ्ट्स, फूड स्टफ।
अच्छा।
चल अब ना किचन में चलते हैं और गर्मा गर्म चाय बनाते हैं।
हाँ हाँ हाँ।
किचन की ओर जाते हुए नानी ने छोटू को अपना देश घुमा दिया।
छोटू,
जी नानी।
ये देख, ये पेंटिंग देख। ये एक मधुबनी पेंटिंग है, बिहार की। और ये है हिमाचल की कांगड़ा पेंटिंग। तेरे नानू को देश की कला और संस्कृति से जुड़ी हुई चीजों को इकट्ठा करने का बहुत शौक है।
अच्छा।
ये कठपुतलियाँ देख रहा है?
हाँ।
ये राजस्थान की हैं। इसी तरह छत्तीसगढ़ से बस्तर ढोकरा, आंध्र प्रदेश से तिरुपति लड्डू, असम से मूंगा सिल्क, नागालैंड से नागा मिर्च और मध्य प्रदेश के बाघ प्रिंट, ये सब रजिस्टर्ड जीआईज हैं।
ओके।
ये हमारे देश की कला और संस्कृति का प्रतीक हैं। हमारे देश में हुनर और कला का इतना भंडार है कि अभी से ही 300 से ज्यादा रजिस्टर्ड जीआईज हैं।
वाह नानी।
चल अब तू चाय बनाने में मेरी मदद कर। एक बर्तन में पानी ले और उबालने के लिए रख।
यस बॉस।
पता है छोटू, तुझे मेरे हाथ की चाय इतनी पसंद क्यों है?
क्यों है नानी?
क्योंकि ये स्पेशल दार्जिलिंग की चाय है। ये देश की सबसे पहली रजिस्टर्ड जीआई है, जो 2004 में रजिस्टर्ड हुई थी।
लेकिन नानी एक बात बताओ, इन जीआई से फायदा क्या होता है?
देखो छोटू, ज्यादातर जीआईज गांव के समुदाय के होते हैं। इनसे कारीगरों, बुनकरों, किसानों की आमदनी बढ़ती है। उनको अपनी मेहनत का सही दाम मिलता है और उन वस्तुओं की डिमांड भी बढ़ती है। साथ साथ खरीदने वालों को भी विश्वास हो जाता है कि वो एक जेन्युइन चीज खरीद रहे हैं।
ओह, वैसे नानी मुझे एक आइडिया आया है।
अरे वाह छोटू, तेरे को आइडिया?
यस नानी, अगले महीने फॉरेन से मेरे कुछ दोस्त आ रहे हैं। क्यों ना मैं उन्हें हमारे देश के कुछ सुंदर जीआई प्रोडक्ट्स गिफ्ट में दूं?
ये तो बहुत ही अच्छा आइडिया है छोटू। उन्हें ये चीजें जरूर पसंद आएंगी और हमारे देश की कला का नाम भी होगा।
देखा नानी, आपकी संगत में मैं कितना इंटेलिजेंट हो गया हूँ।
हाँ भाई, ये बात तो है।
और इस तरह एक बार फिर आईपी नानी ने आईपीआर का झंडा ऊंचा लहरा दिया।
So I hope you all have enjoyed this video. So as IP Nani told you all about the geographical indication, this is the most interesting part of this presentation. In case of the GIs, so we have also, if I talk about the patent office and also the government of India, they have everything for everyone. If small community wants to grow something that belongs to that particular region, the government gives that right to the to those particular community in the form of the GIs, that is geographical indication. So a GI is an indication that identifies the product that have a specific original, that is have a specific geographical origin, and it possesses the qualities or the reputation that belong to that particular region. Abhi, the first image is this Darjeeling tea. So this is the image trademark they are using on that, the Darjeeling tea packets. So this is the recent addition to the GI registry of the India. And next is the Makrana marble, and this is for the Rajasthan. The marble belongs to the Rajasthan, and these are the wobbly Venas that have the GI tag, and Bastar Dhokra India, and Ventagiri saris They belong to the Nerol district, Arunachal Pradesh. And next is here are the other figures that are the handloom sarees, Madurai Wool and Wayanad Ziraksala rice, Surat Cherry craft, Nagpur Santras. They specifically, as you all belong to Maharashtra, you may know that the Nagpur oranges are very famous and the sweetest in the nature, and they hold the GI tag along with them. Nilgiri tea. Nilgiri tea also holds the geographical indication. So here comes the larger view of the previous slide, that is Darjeeling tea. It is the first Indian product to be granted the GI production. And next is the Makrana marble, that is belongs to the Rajasthan. It holds the GI tag from the Rajasthan. Ratlami Save, it belongs to the MP. Madhya Pradesh. Kanchipuram silk, it belongs to the Tamil Nadu. So IP Nani has also mentioned in her video that the Katputlis of Rajasthan comes under the tag of the GI. So what is the importance of giving the GI tag to the particular region? So nobody else, people can make the things from the other in the other states too, but they cannot claim it in the name of that particular region. This is the beauty of the GI tag given to the any specific place. So here comes the bag prints of the Madhya Pradesh, and this is the Bengal Patchatra. This is a very unique kind of the painting that is to made in the piece of the cloth. And this is the Sherial painting, Bidri ware and Varli paintings. And these are some other varieties of the fruits and the plants, or maybe you can see the flowers. So this is the pan leaf, and the Coorg oranges are also there. And nowadays there is a debate going on the case of the Coorg oranges because they have certainly developed some kind of modifications, genetic modification in their oranges. And this is the Shahi lychee of the Bihar, and you know that the lychee of Bihar has the sweetest nature. And this is the Kashmiri saffron, and it is most famous in the world and the most expensive also. And here comes the another video. In this video, you will come across like the time you wake up from your bed and the time you go to your bed, you all are surrounded by the different IPs. So ma'am, now I'm going to play the another video. Kindly confirm with me if you are able to hear the sound properly.
Yes, ma'am. Yes, ma'am. Perfect.
copyright. According to privacy regulator,
So what is the validity of the various IPRs? So for the patents, it is to be granted for the 20 years. And there is nothing called the global or international patent. If you want to get a patent right in other countries too, then you can also, then you need not need to file for the patent application in that particular country. In case of the designs, it is initially for the 10 years and you can just renew it for 5.
करायला पाहिजे दुसरं तुला विषय करून टाकू याच्यात
For the trademarks, it is indefinitely subject to the renewal, and GI is also indefinitely subject to the renewal. For the copyrights, it is for the lifetime of the author plus 60 years. And all IP rights are the territorial in nature. So what are the career opportunities? You can just grab a government job, like I'm also working as an examiner of patents and designs. There are the other examiners too that work in the trademark and GI and copyright also. And if you want to go with the private sector, then you can also try for the post of the patent agent, trademark agent, or you can just try the JRF, SRS in the patent facilitation centers, and in patent litigation and other opportunities which belong to the private sector. So this is the contact detail for the RJNABM. It is Rajiv Gandhi National Institute of Intellectual Property Manage. And when I got this job, then I myself did my 6-month induction training into job from this institute only. So this is the institute that conducts the further the various training program that are organized by some international organizations too. So here comes the quiz. So now, ma'am, I would like to, I'm just expecting some good response from the audience also. So this is a quiz we particularly designed for the audience. So now the forum is also open for discussion for the question answering session. If you want to just ask me anything regarding the IPRs, or if you have any query regarding our office or organization, you can simply ask me. So first of all, we have designed a game. This is a Scrabble game. So kindly help me finding some famous trademarks. One tip is there: go horizontally, then go vertically, and just explore it row by row and column, then by column.
Okay. Okay, I request all the faculty, please participate. Ma'am, because all faculty is on the Zoom link and the students are on the YouTube channel. So I think faculty.
Okay.
Yeah.
Okay. Faculty can also answer, no problem is there. Anybody can answer who is the audience for this program. You can simply type in the chat box also. Is there a chat box?
Yes, ma'am, chat box is there.
Okay, you can simply type your answers in the chat box also.
Okay.
Oh my God, I accidentally.
Yes. That we could. Yes, even I can see Amol.
Okay, so chat box is active. Okay, you have yes, Pepsi is the right answer. What about the others?
Other faculty, please participate.
Cadbury is there, right? Cadbury is there. Babool is there, correct. Amul is there, correct. Correct. Max is there. Bata, correct. Correct. Link, correct. Okay, so I just Supriya Shukla ma'am has written the link. I just want to congratulate you, ma'am. I think across all the presentation I have taken, you are the first person who just identified this link. Yeah,
Thank you, ma'am.
You're welcome. Okay. So this is the answer to those the famous trademarks. This is the Pepsi, Amul, Cadbury, Link, Horlicks is there, Babool, Bata. You have already identified it. Dettol was also there. Tata was also there. Lux was also there, and Amul was there. Okay, the only Horlicks you people were not able to identify. Okay, so that is the great response. Okay, so here are the 5 figures. So in all these figures, you are seeing some kind of IP. So you need to tell me that into which category of IP these images fall. Like this is a painting of Mona Lisa. So it belongs to which category of IP? Patents, designs, trademarks, copyrights, GIs, or SICLDs? Quickly. You can type your answer in the chat box too. आप बोल के भी बता सकते हैं unmute करके. It falls under the category of the copyright. It's correct. It falls under the category of the copyright. And the figure 2, this is a sculpture. This is a form of art, and it falls under the category of which IPR? It also belongs to the category of copyright. No, we cannot define it under the term design, because anything that falls under the category of something artistic work, it falls in the category of copyright only. When we talk about the design, in the case of the design, we talk about the inner outer shine of the article only. Anything that comes under the category that have some artistic emotions attached to it, it comes under the category of copyright. So in the figure 3, there are 3 pictures. Okay, one is the view of a laptop, another is mobile phone, and the third is this is, I think, some device by Apple. Okay, so this is iPod. Okay, so in this figure, try to figure out the different IPRs. It contains the multiple IPRs. If I talk about this Apple logo, it talks about the trademark. If I talk about the mobile phone display, it talks about the patents. And if I talk about the various features of the iPod, if I talk about the logo, it comes under the category of trademark. If I talk about the properties of the technical specifications of the particular display, then it comes under the category of the patents. And in case of the shape and design, it comes under the category of designs. So this is Bisleri. So it comes under which category? So Bisleri is the brand. Yeah. So it comes under the category of trademark. And this is the bottle of Coca-Cola. So it contains the 2 IPs. Which are those IPs? The name Coca-Cola comes under the trademark, and the contour and shape of the bottle, yes, it talks about the design and trademark. Okay, so quickly, these are the questions. Which type of IP protects the painting painted by the artist? Which type of the IP protected by the artist? Copyright, GI, patents, designs, trademarks. So whenever I talk about the artistic work, it comes under the domain of the copyright. Yes, sir is right, copyright. So what protects the intellectual property created by fashion designers? Recently, we all know the big brands like Sabyasachi, they have designed all the clothes of the Bollywood. So it comes under the category of trademarks.
It's nice.
What protects the advanced disc brake for the bike developed by the inventors? What protects the advanced disc brake for bike developed by the inventors? We cannot consider it under the design. Whenever we talk about any kind of invention or innovation that is, adding something great feature, some advancement in the functioning or technical part, it only comes under the domain of patents. Which of these is a GI? BMW, Nagpur Orange, ironing machine with stem, PlayStation, or WWW? Yes, it is Nagpur Orange. So what does a trademark protect? Invention, a work of art, logos, names and brands, or a secret formula? What does a trademark protect? An invention, work of art, logos, names and brands. So it protects the logos, names and brands, and a patent lasts for the 20 years. So if you write something, that is, if you write some original story, and then it comes under the category of copyrights. So here was my presentation. So I hope I have helped you people with some information about the IPRs, and I hope I can expect some of your, at least some of your student or the faculty members to file for some IPRs in our office.
Thank you, ma'am. Is there any question or something any faculty want to ask?
And ma'am, I just also need the photographs of this session.
Yes, ma'am.
For the purpose of emailing it to the AICTC. So kindly
Yes.
take. Yes. So
Okay.
I kindly take care of that also.
Yes, ma'am. So I request all the faculty to switch on video for virtual photograph. I request all the faculty switch on video. Zada sir. Gurav sir, please switch on your videos. All the participants, please switch on video.
it's okay to have some faces in the photograph also. You need
Okay.
to- yes, it's okay.
Okay. Guru sir, please take the screenshot. Okay. Thank you all. Okay. Now moving towards the next one. As per the protocol of the program, we have received an online message from Dr. Mohit Gambhir, Director, Ministry of Education Innovation Cell, for 10 minutes. So I request all of you to listen the message. I will share the message. Just 1 minute. Just I will share one more time.
My warm greetings to one and all present here, all the dignitaries, all the learned people who have gathered here on the beautiful occasion of World IP Day and the celebrations which are being done with Indian Patent Office in collaboration with AICTE MIC to disseminate the information among all the stakeholders across the country about the importance of intellectual property, Bauddhik Sampada. As I always say, no country can ever reach to become a robust economy until and unless that country moves forward and works genuinely and seriously in protecting the IP. And not only protecting the IP, once it is done through the best possible means, then try to commercialize, try to generate revenues. So IP has to be a valuable asset. And in line of that, through Innovation Cell at AICTE, what we are trying to do, since past 1 year, we have started a program named Kapila. Under this program, that is named after our ex-president, Dr. APJ Abdul Kalam, Kalam Program for IP Literacy and Awareness. We started under this program a few kind of small events to engage our faculty members, to engage our students across the country in various colleges through our establishments, IICs, which we have done, Institutions Innovation Councils. And I like to thank everyone who has participated so far and who are trying to gain the maximum out of it. Under this program, we are trying to we are trying to imbibe the culture of innovation, IP generation, then filing that IP, securing the IP rights, and then taking that particular course. Friends, in IP domain, and I'm sure you all are aware of, in many lectures of ours we have said, and the data is presented, that China is way far leading in filing international applications. They are filing in tune of 15 lakhs, and then US is filing in tune of 7 lakhs, and India we see around 60,000 applications per annum. We genuinely need to increase this filing rate. As of now, I believe it's just like I always compare this phase with our own lives. As a human life, what we do. So after taking birth, it is a time of we spend few time in prime, then we start scrolling, then we start standing, then we start taking small steps. Generally, it is being termed as baby steps. Then we walk, learn to walk in a steady manner, and then we starts running, sprinting, running, and take the lead. So these are all a kind of phases. In a very similar manner, if we take it in IP and in protection of IP, we are at the stage of prime as of now, I say. At the prime stage, where like we human lives are being nurtured in a similar manner, I believe the IP knowledge and the filing of IP, it needs nurturing. It may take another few years where we all will understand what is to be done and in what manner. It's again similar, just like learning by the experience. Many people say that what will happen when we are going to increase the number of filing. So I very candidly say, let's increase the number of filing today. Down the line tomorrow, we'll understand what to file. Down the line next year, we will understand what not to file. Down the line another year, we will understand what has to be there in that application. Down the line next year, we will understand what is the kind of drafting or the claims or the value add features we need to do during our ideation process that has to be filed in IPR. So it is again a gradual process. Considering that, coming back to our Kapila program, we proposed and we received the approval from our competent authorities to provide the matching grant to the institutions. Like if an institution is filing 20 applications, we would be providing the grant for 10 applications in terms of filing fee and the examination fee. You all will be really delighted to know, and I'm sure again this information is very well disseminated. Earlier, what used to happen in our Indian context, I am talking about, IP is being filed many times because of the fee constraints. Individual inventors, they used to file on their own name and themselves as an applicant, citing their address as an institutions. But friends, to all the faculty members, to all the students who are listening to me, please understand, we are working for an organization, and if an IP is being generated by utilizing the infra of that organization, applicant should be there as an organization, and to the organizations there must be some clear-cut policy that what inventors would be gaining out of it. There are a lot of policies that has been even proposed by our own innovation cell under National Innovation and Startup Policy. All of you can go there, all of you can look into what kind of percentages and all other granularities are there which can be considered while drafting our own IP policy of your own institution and how things are to be taken forward. Major step has happened last year, August 17, 2021, when Honorable Minister Shri Piyush Goyal ji announced a landmark thing in our IP regimen by reducing the fee for academic institutions to 80%. So I believe then there is no stopper or no blockage for our institutions. And earlier, the hefty fee they were paying, it is now at par with individuals. We need to join hands together. We need to understand the critical nature of this whole IP regimen and come forward in protecting our ideas. There are many situations where we may think, yes, this is an IP and it is to be deployed for masses at large. Certainly, we should do that. Certainly, we should move ahead in that direction. But after protecting our IPRs. As an applicant, as an inventor, you guys have to decide what to do thereafter. But take a step forward. Taking those steps and these steps after steps will only make us leap forward. My dear colleagues, peers, and everybody, all the student and the academic fraternity out there, please work together. I'm sure this whole week, the way it is being celebrated, it is being formed to provide you the desired information. Lot and lot of IP would be generated and would be filed. Thank you so much and all the very best. Once again, thanks to the organizers and the management of the institutions wherever you are listening me, and all the departments who join hands to take it forward. My colleagues, Professor Unnat Pandit ji, Dr. Abhay Jere, our higher authorities, Professor Anil Sahasrabudhe, Professor M.P. Punia, Professor Rajiv. Thanks to everyone who made this possible, Dr. Ellen, Dr. Sonal, who are running the Kapila program. I'm sure together we will be able to achieve today what looks impossible and bring our country the pride we always desire for. All the very best. Thank you so much.
Okay, thank you, Dr. Mohit Gambhir sir, for giving a very beautiful and encouraging message. And I hope all the students and faculty will come forward for filing the patents. So thank you, ma'am, for giving a valuable information. We are moving towards the last session, vote of thanks. So it is my privilege to propose vote of thanks to our speaker, Jasprit Kaur, ma'am, for giving valuable information on intellectual property rights. And I'm sure this will definitely help to our students and faculty to understand it and to come forward to file the patents and to file the ideas of their own. So surely this will work on it, and this is the perfect time. We got the opportunity to know more about the IP and like a patent, how to file a patent, then what is design, patent, copyrights. So you have explained it very nicely in very simple language. So I hope all the students and faculty understand about the details about the filing of the patent. So on behalf of Yeshwantrao Mohite College, Institution of Innovation Council, and Bharati Vidyapeeth deemed to be university, I thank you, ma'am, for giving such a beautiful lecture. And I also thanks to our principal, in charge principal, Dr. V.A. Rankhambe, sir. I also thanks to IQAC coordinator, NIF coordinator, faculty of Dean Faculty of Science for giving support to organize this program. It is my duty to thank our technical team, Dr. Prashant Patil and Dr. Onkar Gurav, for their valuable help. Without them, it was not possible to organize this session. Last but not the least, I also thanks to all our students and faculty for attending the session, and hopefully they will implement their ideas into the patents. Thank you, everyone. Thank you, ma'am. So session is over now. Thank you, ma'am.